All right, everybody, thanks for joining. This is Bill Van Orsdel from BookFuel for this week's Wednesday webinar. I am so fortunate to be joined by Helen Sedwick. She is a lawyer specializing in contracts and copyright. I'm going to let her give her proper introduction and credentials in just a moment. But today we're going to talk about a few of the issues surrounding copyright. There are a ton of issues that you need to be aware of, whether you're writing fiction or nonfiction. We won't be able to cover all of them, but today we're going to focus on some of the mistakes that authors want to avoid so that they can protect themselves financially and still accomplish their goals as writers. Helen, you want to just give us a quick introduction? Is that Helen? Is that you?
That's me. I'm right here. No, that is not me. That is a stock image from Dreams Time, which is where I generally get my stock images from. And I'll talk about stock images in a moment. Welcome, everybody. I'm a California attorney and an author. About 2 years ago, I decided to self-publish my novel, Coyote Wins. And when I finished self-publishing that, it really dawned on me that there were so many legal issues and intellectual property issues that self-publishers were facing, and there was no handbook to help them, from the nitty-gritty things starting from how to set up your business to how to protect your rights. So I've written that book, and my mission is to teach you how to protect yourselves. And so today we're going to do some basic education and information, and also address your questions. So slow down a little bit, Bill.
All right.
We're going to talk about, let's say you have a manuscript and you have it on a nifty little flash drive. We don't know whether that flash drive is worth $4 or $1 million. But we do know that what you've created and put on that flash drive is a piece of property, intellectual property, and it can be protected just like you would protect a car, a bicycle, or a home. So let's go to the next slide, which is our cute little puppy. Oh, and the next one, the protect a home. My goal today is show you how to maintain control of your property, just as you would want to control who sleeps in your house or who drives your car. We can move a couple slides now, because there are companies out there that run contests, and the prize is they get to control your work in all formats, in all languages, for the next 100 years or so. And there are self-publishing companies with very sticky fingers. Once they get a hold of your manuscript, it's very difficult to get it back. So let's take a look at what you own. It's called a copyright. A copyright attaches as soon as you put something in tangible form, on a piece of paper, a flash drive, a computer, even if you never fix the typos. Yes, years ago you had to publish and mark and register your copyright in order for it to last and be valid. But that's not the case anymore. It's automatic. And it lasts for a very long time. For works created today, the copyright lasts for the life of the author plus 70 years. So if you write a book today and you live another 40 years, the copyright will last 110 years. So your great-great-grandchildren could still be getting royalties. Now, what about C in a circle? Do you still need to use that? Technically, not anymore. The copyright attaches whether you mark it or not. But it's a really good idea to mark your work because it puts people on notice. This is the correct way to mark it, either C in a circle or the word copyright, the year of first publication, then your name or pen name. I also like to put all rights reserved. That is not legally necessary, but under these things called Creative Commons licenses, which I'll talk about in a little bit, some people mark their work some rights reserved or no rights reserved. So you want to separate yourself from those people and keep your all rights reserved. Now, a lot of people say that they copyrighted their work. They usually mean that they registered the copyright with the U.S. Copyright Office. This is a separate step. You own the copyright regardless of whether you register it. But registering is a very good idea. If someone steals your work, you can't sue them unless you register. And if you register within 3 months of your first publication, then you can recover attorney's fees and statutory damages. And trust me, that's what you want to do. It's inexpensive and easy to register your copyright. You can do it online for $35, plus you send in 2 copies of your work. If you're interested in registering your blog or your website, that can also be done. It's considered an unpublished work, and I wrote a blog post about it. Most people don't bother with their blogs and websites. It's kind of giveaway content. So what's protected by copyright? Manuscripts, books, poems, blog posts, images, songs, musical notations, architectural works. But what's not protected by copyright? Ideas. This drives some writers crazy because they're sure their idea is worth millions and someone's going to steal it. But let's think about this. How many times have you had what feels like $1 million idea, but after writing about 10 pages or 2 pages, the idea peters out? What copyright protects is the execution of the idea into a story, movie, painting, piece of music, but not the idea itself. Also not protected by copyright are historical facts, people's names, events. So anybody can write a story about, this is Charlie Chaplin in an early photo, or here's another photo that just passed was about the Dust Bowl. John Steinbeck does not own any copyright in the story of the Dust Bowl. You could write about it as well. Also not protected are gangsters and other typical, stereotypical characters.
How about, Helen, I got a question for you. How about book titles? Oh, no, here it is. That's one thing not covered. Right, there we go.
Book titles and song titles are not protected by copyright. This comes as a surprise to many authors because coming up with a good book title is so hard. You would think that has to be protected. Copyright does not protect short phrases, and most book titles are fairly short. And the same with song titles. So although you can't protect your book title, that also means that if you want to reference a book title or a song title in your writing, someone else's work, you can. Other short phrases are also not protected. Some people say 15 words, some say 30 words. That's how sites like Canva and these other sites where people take quotes and put them on beautiful pictures, that's how they get away with it without infringing on copyrights. But I will carve out from that lyrics. Song lyrics, it's very tricky and risky to use song lyrics in your writing. That's not because the law treats song lyrics as special, but because they're owned by music companies, and they're very aggressive about enforcement.
So that leads me to a topic, Helen, to ask you, how, I might work with you, or I might walk out of this session and say, okay, well, it sounds like I can do that, but there might be people out there who, even if they have a weak case, if you will, still might want to sue me or send me nasty letters. So, I mean, I guess there are some rights I have that I may even still not want to exercise.
Yes. Most actions have some risk involved. And there are general rules that can help people assess the risk that they're taking. If you're going to quote from a particular article or somebody else's work, and you're using more than 15 or 20 words, or 100 or 150 words, then you really need to educate yourself. Sorry, I have a bit of a cold, and nothing is working quite right here. Educate yourself on what risks you are taking when you use somebody else's work. There are exceptions for fair use. There are exceptions for the work might have fallen out of copyright. All I can speak to is kind of general concepts so that people are aware. They're what we call in law issue spotting. You recognize there's an issue and then you evaluate it. And if you have to, then you talk to an attorney, or if you have an agent who's fairly sophisticated on the law, you talk to them about how the law, in a general sense, applies to your specific question or your manuscript.
Okay.
And then there's always what I call the ME factor, which is money times emotion. It's basically the likelihood of getting sued is the more money that's involved, the less emotion that's required. But even if there's not much money at stake, but you've really provoked a lot of emotion, and that person has a deep pocket, or that company has a deep pocket, you're running a higher risk, and you just have to decide whether this is a risk that you can mitigate or that you can live with.
Okay.
Okay? And that applies in all kinds of areas. So here's a nice quote just to show how these quotes are all over the Internet. And let's talk about a little vocabulary. Now that you know what you own, how do you protect it? If you're going to be publishing or self-publishing, you're going to be signing a lot of contracts. So here are some key legal concepts and words to know. Exclusive versus non-exclusive. If you give somebody exclusive rights to, let's say, produce audiobooks for you, then nobody else can produce an audiobook. It's exclusively theirs. You can't even produce your own audiobook. Non-exclusive means that many people could be, let's say, distributing your ebooks. In publishing, what you generally give are what's called a license, which is a permission to use. You're not transferring ownership. If you were transferring ownership, it would be what's called an assignment, and you should be very careful if you ever see anything with the word assigns in it. That's a transfer of ownership. It's rare, except if you're ghostwriting or if you are freelancing or a freelancer's doing something for you, and you are going to own it at the end.
Oh, so for example, if I'm doing a children's book and I've engaged an illustrator, I want the illustrator to assign to me the rights to the illustrations they've created.
Yes, and typically you'll give him permission or her permission to use those illustrations in a portfolio or on their website, so long as they say that it was prepared for you and your book.
I've also heard on that topic that because I know we work with a lot of folks who are writing children's books. I've also heard that illustrators are careful when they do the assignment, or they should be careful, or they want to be careful, or you need to be aware that they want to be careful, that they're not assigning to you their drawing style of a particular character or cartoon, because that's how they make their living. They may only have one or two or three or half a dozen styles of animation, and so they're not transferring to you the right to draw big heads with little bodies and stick knees. I mean, I'm making that up. But so when you're an author contracting and receiving assignment, aware that there'll be limitations on it.
Yes, that's a very good point. The same with fonts, particular typefaces, that there's supposed to be there's a free market in things such as styles, concepts, the words that we all use in common. It's how they're put together that's protected by copyright, not the fundamental components.
Okay.
Like a recipe, everybody owns, it's how you put the pieces together that creates the final product.
Right.
The last two vocabulary terms here, reversion, is more of a traditional publishing concept, is that at what point do the rights to your work come back to you? This is heavily negotiated in traditional publishing contracts. And subsidiary rights, there's this bucket of other rights, movies, plays, stuffed animals, foreign rights. So I'm focusing on self-published authors now and want to talk a little bit about what a license is.
Mm-hmm. And before we get to the licenses and subsidiary rights, I do have one question I think would be relevant to enter now from the audience. Excuse me, I've got a little bit cold too. Donna asked, she said, I published one poetry collection through a self-published printing company, and that was in 2008. I had a 7-year contract with them, which runs out this year. Would my rights to publish permit me to republish the collection as an ebook? This sounds like a reversion question to me.
Somebody will have to look at your specific contract, because a contract is basically you wrote the law as applies to your relationship with that publisher or printer. All those are quite possible. It's also quite possible that if it was 2008, the contract is silent about ebooks.
Oh, yeah.
So that's probably something you're going to have an attorney look at your contract and give you some specific advice. Mm-hmm.
Good point. Oh, and then before we jump on to some series and managing the apartment, one more question that came up when we were talking about permissions of, and here's Samantha's question. What if you have permission directly from the author of the song? Or, second case, if the song is based on traditional anonymous lyrics? And I assume that the question is, could you use those lyrics in your book if one of those two cases was true?
Let's talk about the first one. What happens typically in the music industry is songwriters assign or give an exclusive license to a music publisher to their lyrics. So in most cases, the author no longer has the right to give you permission to use his or her lyrics.
That recently happened, by the way, to David Bowie for his song that was used by his song Major Tom that was used on the International Space Station. He wanted to give permission, but he couldn't because his song publisher wouldn't do it for him.
Right. In the same way, a lot of songs get sold by the music publisher for political purposes or for certain kind of advertising, and the songwriter is appalled. But they sold their soul in that case. So I have an ebook that talks about, and I'll show this later on, but I have two just 99-cent ebooks about how to get permissions, one for images and one for lyrics, and where to look to see who owns those rights to the lyrics, because you don't want to get permission from the wrong person.
Right. Okay.
And then
the second case.
Lyrics, music, lyrics, images, they all can eventually fall into what's called the public domain, which is work that was first published prior to 1923, and then some other works. So if it's a really old song from the 1880s or the 1910s, something like that, then yes, you can use it without having to get permission. Because if it's in the public domain, then anybody can use it. The copyright has expired.
So Samantha's question about anonymous lyrics is a case that bears further investigation to understand whether it's available or not.
Yes.
Okay. Great. Okay, I've got the house.
Yeah, when you're thinking of a license, think of it as if you own an apartment building. Your book or your work is a whole apartment building. So you want to rent out just the space like if you want to do audiobooks in Spanish, you want to give that distributor or that publisher just that room. Only what they can use and what they have the wherewithal to actually make some money on. Or it might be children's books in Mandarin. But what you don't want to do is you don't want to give a publisher the whole entire apartment, unless it happens to be a big 5 publisher and they're paying you a lot of money. But there are that's like basically hiring a contractor to build your house, and then he gets to live there. And there are contracts that do this. So And how do you know what a contract's going to say? You're going to have to read it. This is a little intimidating, but I strongly believe that a writer who can master character, plot, pacing, can learn to read the key provisions of their contracts, and I will show you how. I know contracts look like this, 5,000 words run through a blender. So let's take a quick look at, I'm just going to give you some examples of what to look for. There's the blender going right down the drain.
Perfect.
Okay, let's hit it one more time.
There we go. There we go.
You're going to need to start when you have a contract to look at, and I'll show you some examples of really bad ones. You have to look at the section that's called grant of rights or license or ownership. And then you're going to look at how to terminate the contract. If you see problematic phrases in either of those sections, you don't need to read the rest of the contract. These are the most important provisions, and they really, if a company is unfair in how it treats its authors in these two sections, then you can pretty much be assured it's unfair to authors in many other ways.
So just to clarify, Helen, so you're suggesting, I think it's a good suggestion, I think, that not only should I perhaps look at the contract that a traditional publisher, whether they're Big Five or whether they're a small indie publisher in Des Moines, the contract that they might give me, and to read it and understand it myself. And then, of course, at the bottom you say, of course, don't go it alone, get a competent attorney to help you. Not only should I do that, but should I also be looking at the contract from Author Solutions or Publish America or WaveCloud BookFuel or whoever it is, or Amazon even, whoever it is that I might give the right to sell on my behalf or make copies on my behalf and sell for me? Do I want to be this thorough with everything, or can I just assume that because they're online, they're safe?
I would not assume that because they're online, it's safe. There are companies that are more fair to authors than they're not, and others that are not. Anytime you give your work to somebody and you're giving them rights to sell and distribute it, then you should take a look at these two sections. One thing to keep in mind is that there are companies, oh, no, it's okay, you can go to the next slide.
Okay, all right, sorry.
Just basically the quick distinction between traditional publishing and self-publishing. Even if a publisher pretends to be a traditional publisher, as soon as they start asking you to get out your credit card, understand that you're self-publishing. Okay?
Right, that's a good distinction.
Companies out there that pretend, or they call themselves hybrid or assisted, it's still self-publishing.
Yep, shared or cooperative publishing. Yep, I've seen those too.
Cooperative publishing.
Right.
So let's take a look at an example, because I think this makes the most sense if you look at an example. This is an Author Solutions grant. This is a group of companies that has a terrible reputation, and a well-deserved terrible reputation. If you see, look at the second line here. It says, you grant to us the exclusive, transferable, worldwide license to manufacture, blah, 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 your work, all distribution channels, any language, print, digital, audio, any other medium now known or hereafter devised. This is an incredibly broad provision, and this is not typical in the self-publishing world.
And this is a provision that you paid to enter.
Yes.
You paid money so someone could lock up your book like this.
If Author Solutions were a traditional publisher, and they were the ones paying for editors, designers, distributors, printers, then they would have the right to have exclusive rights because they're putting an investment into it. Author Solutions isn't investing a dime. The author is the one paying for all these services. Author Solutions is merely a service provider. So this is the kind of thing you want to avoid. Any company that takes an exclusive right for this broad a swath, it makes no sense for a self-published author to do that. The author should always think of themselves as being the publisher.
Right.
Author Solutions or any one of these companies, BookBaby, Blurb, they are not the publisher. They are merely a company that's providing service to you, the author, as a publisher.
Now, to be fair, BookBaby, Smashwords, BookFuel, WaveCloud, the companies that are service providers, they might have a clause that says, if you're going to ask us to sell your book in our store, you give us the right to produce an electronic copy when someone buys one, but you can cancel at any time. We don't own any rights, and so on and so on and so forth. So you might be granting some rights to companies like BookBaby and BookFuel and Smashwords, but nothing like this.
Correct, and it's usually limited to what they can do for you.
Right.
Smashwords is going to say digital forms in the various places they sell books through. You might be working with somebody who is investing some expertise and even some money in your work, and you might want to grant an exclusive. So then you really want to look at how do you exit this relationship if it doesn't work out.
Got it. Okay.
I'm going to take a look at a contest here. There are lots of contests out there. You win a publishing contract. I just want to show you an example of what you need to look for. This is a company that's kind of struggling, and it does children's book apps, so that it's books that can be looked at on an iPad. They ran a contest, and if they accept your manuscript, then they took exclusive worldwide perpetual rights to that book in print, audio, sound, or any other version. And then on the next page, it goes on to say they can also do derivatives, series, merchandise, movies. They take everything.
So just for entering, just for uploading my book and press the yes, I want to enter, and who knows, maybe even I paid an enter fee to MG. They took all these rights, and I agreed to it by clicking yes.
Right. And actually, the way it reads is if you don't hear from them in 6 months, then you get your rights back. But you're supposed to not even pitch your book to somebody else during those 6 months. So this is the fine print stuff that writers need to get over the intimidation and look at. If you know what words to look for, you will be able to spot something that makes you feel really uncomfortable, and as I said, issue spotting, and then ask for help if you need to help to understand it. So the bottom line is don't sign what you don't understand. I'm going to make a transition here to talk about work using other people's work. And I just want to ask the question. People don't have to answer, but if you see an image on the internet and it doesn't have a copyright symbol on it, can you use it? And the answer, hopefully everybody knows, is false. You can't use something just because it's on the internet. As we mentioned earlier in the talk, it's no longer required that you put a C circle or mark work in order for a copyright to attach. It's automatic. And in fact, you are more likely to get a lawyer letter demanding a couple $1,000s in payment for posting a kitten photo than for downloading a movie.
So I'm looking for that eye-catching image for my blog because I've been told I have to blog to drive traffic and I'm looking for kittens, and I'm looking for puppy dogs, and I'm looking for starry night skies, and I'm just opening myself up to trouble.
Right. And this is the reason why, because there's a company called Getty Images, which owns, they say, 80 million images. And they have search engines that search the internet to see if somebody has used one of their images, and they're very sloppy about even looking at their records whether you bought that image from one of their companies. But they send out these letters. If you search online for Getty extortion letters, these are all over the internet. I think they make more money from sending these letters out than from selling images. That's just my opinion. So there is a way to, if you find an image and you just have to use that image, learn how to search for images on the internet. Just search on that. It takes about 2 minutes to learn. That way you can see if the image you want to use is on a stock image site, then spend $5 and go buy it.
Sure, sure.
And you'll just be better. A lot of people, you'll hear the word fair use. I'm just going to go over this quickly. Fair use is a lot more narrow than people think. Fair use is that you can use copyrighted work for education, criticism, commentary, parody. The courts take these factors into consideration. But let me give an example about this. If you were to use song lyrics for Bob Dylan and Eminem to talk about and contrast their treatment of women, that's probably fair use. But if you use some Bob Dylan lyrics to kind of set the scene in your novel or your short story, that is probably copyright infringement. And if you think about it, you're using the lyrics because you're trying to capture the magic of those lyrics, the creation of those lyrics, and you know, the creator should be compensated for it. And let's see. So just to kind of summarize about warnings about using work created by others, don't pluck images, blog posts, etc. off the internet. Yes, there is a culture of linking to things. That's acceptable. I think there's an implied permission to do that. Infringement in any kind of legal entanglement is, even if you could win it, it's a lot of money and a lot of stress, and I think writers are better off spending their time writing. And remember, if you do want to use a song or a book title, you can, if you really would like to use lyrics and you're nervous about it, you can always use the title of the song and the songwriter's name without permission.
Right. Okay.
And let's see.
So if I still want to have images. I still want to. There are places where I can go and find where either someone else has already secured licensing and will sublicense to me. That's like iStock Photo, iStock Music. I can search Creative Commons. So there's choices. There
are choices, and we'll just kind of skip over these a little bit because I would like to get to people's questions.
Okay.
As I mentioned, public domain is before 1923. A great source of images are works created by federal agencies. I'm going to show a sample of those. Museums are finally realizing that all their images, all their public domain work, ancient, old paintings, etc., they're starting to make those available online. There are millions of images available for free or for very little money, and so there's no real reason to take the risk. Let's see. These are just images I pulled off the Library of Congress or NASA site. You can get moon launch photographs. It's great. And then Creative Commons. I won't spend a lot of time on this because this could be a whole other discussion. But Creative Commons is a company has come up with a set of icons that if people want their work to be, they want it to be freely used by others, they can put an icon on their work. Each icon has a different set of limitations. So it does take, it's something, if a writer spends 10 minutes learning about Creative Commons, it's become a great source of additional images for a blogger or a writer to use. So just be aware that this is a great resource that's growing every year, more and more people.
Marvin's got a question for us, and I'm not certain, Marvin, I understand if you give us some more detail. He says, how about content sharing?
Content sharing usually is done with Creative Commons licenses. People post their content and they mark it as being available for others to use either commercially or non-commercially under a Creative Commons license. You'll see on Wikipedia has, at the bottom of the page, has a Creative Commons license.
Got it. And I think Marvin added an update here. He said he's talking in this case about sharing stories that he has written, and I assume this would be probably Creative Commons might be a good way to do that.
Yes, and then there's sites where people post work and it's collaborative work online.
Mm-hmm.
I can tell you as a lawyer, those make me very nervous. Who owns them? So I wouldn't even know how to approach who owns that work. I think if you do it kind of as a writing exercise, it's great. But if you actually had to sort out who owned these online collaborative works, it would be a real mess.
Mm-hmm. Now, you said, I think you mentioned earlier, you've got a couple of 99-cent ebooks on the right way to do lyrics, images.
Yes, I go through a little bit more discussion about what's the free resources and then the low-cost resources. And then for lyrics, if someone really wants to use lyrics in their writing, the good news is for print rights, it's usually very affordable, like somewhere between $20 and $60
mm-hmm.
to get print rights for most songs. Now, that's not going to get you a Rolling Stones song, but it might, but if you're trying to create the scene of 1940s, a wartime scene, and you want lyrics from an old Frank Sinatra ballad,
mm-hmm.
you're probably talking $40.
Yeah.
So depending on your budget, it is doable.
Now,
and so I explained how to find who owns the rights and ask permission.
Yep, and then so of course I might have the dream that my book does well, and it's a series and it does really well. Book number 2 does well. And before I can get book 3 or 4 out the door, a publisher comes to me and says, I'd like to talk about helping bring the rest of your series to market. And of course, when I do that, I'll want books 1 and I'll want the copyrights. I want you to license the copyrights to books 1 and 2 to me. I assume that if I've used lyrics or used images in my books, I probably want to have kept a paper trail of all of the permissions I've got to make a deal like that happen or easier, not be an objection from the publishing house.
If you haven't done your homework before the publisher comes, the publisher will make you do your homework then.
Yeah.
Make sure you have all your rights and organization. That's a whole another topic is realizing that when you're self-publishing, you are setting up a small business, mm-hmm. and so you need to start treating it like a small business. Get a file cabinet. Keep track of these things, because you want to plan for success.
Right.
You want to be ready for when opportunity comes, that you've done a pretty good job getting your ducks in a row, and it's part of the process, just like mm-hmm. copy editing.
Mm-hmm.
I just wanted to mention about stock image companies. Here are some of them, and the next few, just to show you kind of mm-hmm. the range of images. If you just scroll through the next few,
yep.
These are all images that you can get online.
We got a question here from Daniel real quick. He says, how about those old photos from the Victorian era that are posted today? Are they still copyrighted?
If they were first published before 1923, then they are not protected by copyright anymore.
Okay.
Sometimes people find old photos that have never been published, and so those might be, that requires a little bit more analysis.
Mm-hmm.
But if it was from a magazine or a newspaper from 1922 or earlier, then it's in the public domain.
All right. So, and I don't know the answer to this. So I see on the internet a picture that looks like it was clearly from the trunk when the family came over to America the first time, and so it was taken and might even been in an old newspaper article, obviously published a long time ago, and it's in someone else's article or in someone else's book. Can I just take a scan or a photo of that photo and say, well, so I can use it now even though it was in somebody else's work recently? That's okay because the photo itself is out of copyright? As long as they didn't do something transformative?
Yeah, as long as, yes, if they changed it in any way, they might own the changes.
Mm-hmm.
I mean, not if they took out little spots and marks or mars, but if they really edited the photograph, their changes they might own. But the work that's in the public domain remains in the public domain. And let's think about this. It's like Shakespeare's plays. Just because somebody stages a Hamlet or does a film of Hamlet, that film and what they changed to make that film is subject to a new copyright. But the play, Hamlet, and Shakespeare's words remain in the public domain, which is why we have so many remakes of Pride and Prejudice and Romeo and Juliet. And the same thing, same rules apply whether it's a single photograph. If it's in the public domain, the original work that's in the public domain remains available for anybody to use. If someone translated it, the translation, to the extent that its original material would be protected, but not the original book.
Mm-hmm. Got it. So the performance or okay, got it. All right. So now we've got two.
And then, Bill, we can just let's just stay on this. We don't need to go any more slides. I just want people to be aware that your email box is going to be flooded with offers. Some of them are outright scams. Most of them are just myths. I mean, you actually do get your name on a special list, or you might get a media package, but the sales that they promise probably won't appear.
Mm-hmm.
So look at these offers with a skeptical eye. Be aware that there are a lot of these. I'm very wary of companies that have a very slick website, but they don't really have much substance on their website, or they don't really have much credentials, and that you can't get information about their services and their costs unless you fill in some form or talk to some person and get subjected to aggressive salespeople.
Yep.
I like to be able to do my homework myself online without having to deal with somebody. I don't know what the audience is, but you should be aware that these companies particularly target the elderly, people who are writing their memoir, who don't want to appear out of touch or slow, so they end up being reassured by some of these salespeople. And what particularly happens with the elderly is when they realize they have been conned, they tend not to complain about it or tell anybody about it because they're so embarrassed.
Yep.
So be aware there's some just really outrageously expensive offers that are going to come your way. And it's tempting because you think with all this work, if you just pay $99 more or $299 more, you're going to break through. Just look at these with a cynical eye. Actually, we'll go to the next slide because these are sites owned by Author Solutions that pretend to help you choose your self-publishing company, but it's, they take you through a little questionnaire, but it's always going to be one of their companies because they own these. And then there are some sites that people can use. Contests are another one. I should go to the next one. These are some sites where if you want to research the reputation of a company or a contest, look at these sites, and including my own, or search the name of the company plus the word scam or complaints or sucks, and do your research. That's how people post these things.
I know. It's good. I love it. Okay. All right.
Okay. So let's take some questions here.
I want to show the cover of your two books, and then while we're doing that, let's take some questions. I've got a couple up here, and this is a great time for folks to throw them in. The first one's from Christine. Hi, Christine. Thanks for joining. First question from Christine. How does an author protect themselves from a lawsuit when they're fictionalizing a real person in their novel? I'll assume that in this case, Christine, she's referencing the possibility that the person I'm fictionalizing isn't going to like the depiction, hasn't given me any permission, or maybe doesn't even know that I'm thinking about doing it. How do I protect myself as an author? And don't is one option, of course, but what do I do?
Okay. First, let's talk about what the potential claims are. And you really, a writer has to be pretty, you have to post either very damaging material that's false or private in order for them to have a reason to complain at all, legally. But if you are going to be doing this, because it's always the really juicy, nasty stuff that we want to write about, change the physical characteristics, mask that person's identifying characteristics. Don't try to make it clearly that person, keeping the name almost the same, etc., because you really want to poke at them. Get past that. Make it more of a universal character. Mask their characteristics and add a disclaimer at the beginning of your book that, this is a work of fiction. Any resemblance to real people or events is merely coincidental. You just look at any piece of fiction, you'll find that kind of disclaimer.
Okay.
So, again, you really only have to worry about very extreme conduct, bad conduct.
Is there any protection in creating a pen name and hiding behind a pen name?
There is, but that just really slows people down.
Yeah. Okay. It's not great. Not great protection.
If you really, they could. If you're self-publishing and you're posting everything, selling it through Amazon or through Ingram Spark, they know who published the book, because they're sending royalty checks to somebody.
Yeah,
and
right.
If they're compelled by court order to say who wrote that book, they will say so.
Right. Okay. Christine's got a question for us. Sorry, Christopher's got a question for us. Here we go. So we were talking before about discussing collecting permissions. Christopher's got a couple of images that are critical to his work that are owned by museums. So he says the images are owned by museums, and I think based on what you said before, there's some question there about whether the image, whether the museum owns it. Obviously, let's assume they do for whatever reason. They charge a license fees scaled based on volume of production. I thought once I had a publisher lined up, we'd know approximately the volume to figure out the license fee. I think I just heard you say that I will need to license the image in advance of finding the publisher. Could be a real hit in the pocket. Could be a real hit in the pocketbook. How do I guess the volume?
It is a guessing about if you're self-publishing, pick your wildest dreams because you'll be paying for it. If you're self-publishing and you think you'll sell 20,000 books, which will put you into the top 3 or 4% of self-published books, put that number down, and if that's too high, cut the number in half or something.
Yeah.
If you're going with a traditional publisher, they're the ones that are going to be paying for the license. So let them decide how much they're willing to pay, because they've already done the business plan for your book, and they already have an idea how many they're going to print and what kind of sales they're expecting.
Mm-hmm.
So if you're going the traditional publishing route, just let them make that decision and pay that money.
Yep. Okay. Christine's got.
That answers the question.
I think so. Christine's got a question for us. It says, "Okay, sales tax. I'm at the author table at a writing conference in a state where I don't live, and I'm going to sell a few of my books. Do I collect sales tax, remit it, and register with that state?" I think I know the answer to this question, which is it not only varies by state, it can vary by county, it can vary by city.
But generally, if you are in the state and you're handing the book over at that conference in the state, you are supposed to be collecting and paying over sales tax. Mm-hmm. Whether anybody's going to know you were there and track it down for 1 or 2 copies, the world is full of risks. You'd have to decide whether that's a risk you can live with or not. But technically, yes.
Got it.
And in but if you go back to your home state and ship it out of state, then most likely you don't have to pay sales tax. So that's the other way around it.
So you take the orders and then you ship it when you get home to another
Right.
state, another taxing venue.
But that could cost more than paying the sales tax.
Sure.
The
Okay.
sales tax might be 8%, and shipping it might be $2 or $3. So.
Yep. Samantha's got this either a question or a comment. She says, what about parallel evolution? You have an idea similar to someone else's. You've never read the other work, but they are really similar concepts about, and I'm making this up, the zombie apocalypse. So I'm guessing Samantha's saying, am I protected because my idea is an idea, and so what if someone else had the same one? I can still write about it on my own.
Yes, you can. If for someone to claim that you infringed their idea, they'd have to show that you actually had access to their work, and they'd have to show quite a few similarities, like word-for-word similarities, structural similarities. To prove infringement, independent development of similar concepts is protected. It's copying, actual copying, that's not protected.
We've got a question here from Donna. She says, how do I contact you for representation? I just advanced the slide one set, Helen, to show your website.
Okay.
How would you feel, Helen, about either you or I sending out this presentation to today's attendees?
I am fine with that. When you contact me through my website, you'll see a disclaimer where I will say that all I can provide is general information. I cannot be soliciting business because that is a big no-no. If I'm only a California attorney, and if you're in Louisiana, I am not soliciting business from you. But I am very generous in terms of giving people general information and legal guidelines. And if I think you should hire an attorney in your jurisdiction to deal with your specific issue, I'll also tell you that. So those are the parameters I have to live with.
Okay. We've got a quick question here from Jennifer. I'll try and answer it, and you might have a legal answer for it too. I am self-publishing a book. Should I use my name or my series name as the publisher? Jennifer, my advice would be I don't know if I would actually use either. I would come up with a publisher-sounding name because if there's any value that a potential purchaser of your book is going to assign to a publisher name, it'll be lost if you use your own name or use the actual series name of the book. And you never know if you might write another series. So I would, if the name of my publishing entity is Singularity Publishing. I write science fiction. Right. Maybe there's a legal answer to that.
Well, I also think that if you're you should set up a self-publishing company and give it an imprint name. A lot of what the name you choose is what kind of domains are available. Since my first book was set in the West, I went through and searched all kinds of names till I found something, and I came up with 10 Gallon Press, which I was really delighted was available. So my books say that they were published by 10 Gallon Press. It's a DBA for a sole proprietorship. I am 10 Gallon Press. If you sign up for my newsletter, one of the things I give out is how to set up your business and choose a name and set it up as a sole proprietorship. It's not that hard to do. It's another webinar.
Sure. Yeah. Well, we can spin. Maybe we will if we can possibly get you back. We'll spin off a few more webinars. Okay. Lynn has a question. I think she's got two, but I think we can concatenate them. So, where is the best place to find the wording for your copyright that will appear at the beginning of your novel, and what should you avoid in the wording? So I think Lynn might be asking about this, about the any similarity, the blah 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 is unintentional part.
I would just pull things off your bookshelf. You'll find that they're more alike than they are different. There's no magic words, but especially if you get something from a large publisher, they probably over-lawyered that thing to death.
Okay, perfect.
Yeah, piggyback on their lawyer work.
Right. Okay. I just advanced the wrong thing. Okay, so I want to go back here real quick. Okay, so question from Elise. We envision that our book will be a wonderful animated feature film. But we have heard horror stories about studios stealing ideas. Keyword ideas there, I think. How can we protect ourselves in the process of pitching it to the studios?
You can require before you pitch that they sign what's called a non-disclosure agreement. It's worth a try. Generally, if you ask either a publisher, an agent, or a movie studio to sign a non-disclosure agreement, they will laugh at you.
Yeah.
That's the problem, because it will mark you as a novice.
Yeah.
Unless you're a really a powerful person who can get them to do what you want. So in theory, it's there. In fact, I have a form on my blog if you're looking for a non-disclosure agreement. It's one of the risks you have to take. If you want to, you can register the work as an unpublished work or published, depending on its stage of development with the Copyright Office. That might help. But if they like your idea, they could take your idea and get a new writer to create it, and there's not much you can do. There have been lawsuits that mostly people have lost.
Yeah, I hear this from screenwriters all the time that
Yes.
It's real tough to protect your ideas. You can certainly protect your screenplay because it's your expression of the idea, but protecting the idea behind your new hit show, police procedural, whatever, is very tough.
It is very tough. It's just a flaw in the system, and writers are not the most powerful people, and we write for other reasons.
Right. Yeah, they are usually at least in a film production, they are often the least compensated. And Elise mentions that her book is already published. Okay, fantastic. Okay. We have hit the end. Thank you so much, Helen. I've learned a lot today. I think we even maybe have spun off a couple of ideas. If we could possibly invite you back, we'd love to have you back. Thank you, everybody, for joining today. I hope you found it valuable. I will go ahead and send Helen's deck out to everyone. So look for that, or maybe we'll make it available for download on the website. But thanks again, everyone, for joining. Thank you, especially Helen. And everyone, I picked up a copy of this Self-Publisher's Legal Handbook. It's good. If you want to get the basics, it's a great book, and it's available on Amazon. Thanks for joining, everybody.
Thank you.